Thank you, Micha. Thank you, Dr. Šepec, again for this honor of moderating the first panel today. I will share the first panel with two other distinguished colleagues, a lawyer from Italy, Mr. Nicola Canestrini, and Professor Dr. Peter Rakov from the Georg August Universität in Göttingen. So we will share this panel. If you allow me, I would start with some historical perspective, because I was involved directly in the legislative procedure when the European investigation order was adopted. This procedure took basically from 2010 till 2014. So I would like to give you certain insights into this legislative procedure from the perspective of the European Parliament. The first point I would like to mention is that this legislative proposal was quite unique in the sense that it was not a proposal from the European Commission. As you know, in the field of criminal law, there is an exception that besides the European Commission, also a group of member states, 1/4 of member states of the European Union can make a legislative proposal. This is a kind of remnants from the former third pillar, that this particular prerogative is still there for a group of member states. And this was the case for the European investigation order. In April 2010, there was such an initiative by a group of member states. By the leading one, or one of the leading ones, was Belgium, followed by Bulgaria, Estonia, Spain, Austria, Slovenia, and Sweden. So these were the member states who proposed this particular instrument. The instrument in the original form as proposed would be quite different for what you can see today. In the original form, this instrument basically would more or less establish automatic mutual recognition. They provided for only 4 non-recognition grounds, and if I remember correctly, not even nebis in idem. The prohibition to be tried twice as a very prominent fundamental right was initially included as one of the non-recognition grounds. So a very, very limited amount of non-recognition grounds. In the original proposal, where you have to make also an assessment as regards the impact on fundamental rights, only 2 fundamental rights were mentioned, that only 2 fundamental rights will be affected, and namely the right to liberty and security and the right to good administration. I have to admit sincerely, when we received the proposal to the European Parliament, some of our members were a little bit astonished, because of course the impact on fundamental rights through the European investigation order is much bigger. You have the right to privacy, defense rights, privilege against self-incrimination. So a whole panopticon of different rights is affected. However, in the original initiative, only 2 rights were mentioned: the right to liberty and security and the right to good administration. In the Parliament, how does it work? Briefly, when the file comes to the Parliament, it's given to the responsible committee. In this case, this was the Committee for Civil Liberties, Justice and Home Affairs. And then we have an internal distribution procedure. The rapporteur was nominated from the biggest group in the European Parliament. This is the European People's Party. It is a member that is still a present member of the Libe Committee from Portugal, and who is also a shadow member of, let's say, of a follow-up of the European investigation order. E-evidence, this was the rapporteur on the European investigation order, was Mr. Nuno Melo, who was a lawyer from Portugal. And then the other groups also nominate shadow rapporteurs. These are the members of the Parliament who closely follow a particular file. It was, I have to say, quite an interesting group of people, of members dedicated for this report. So you had Mr. Melo from Portugal, who was a lawyer from Portugal. Then you had, for example, for the Social Democrats, an experienced politician, first Mr. Crocetta, but then he became president of the region of Sicily. So he was replaced by Austrian member, Austrian professor, Mr. Weidenholzer. We had also two UK members for different groups, for the what is today the Renew group, the Liberals, ALDE, and another British UK member for the ECR group. So one of them was a former junior minister in one of the UK governments, Lord Kirkhope of Harrogate, and we had another UK member who today is also a member of the House of Lords. This was Baroness Ludford. So it was, in this sense, quite an interesting, let's say, group of people on the side of members of the European Parliament who were dealing with this particular file. It took us internally more or less 1 year and a half, almost 2 years, to have an internal position due to the complexity of the file. Then in the trialogues, it was also a very difficult procedure for trialogues. We had 9 trialogues, if I remember correctly. We started with trialogues, I think, with the Cypriot presidency. I don't remember correctly, but we finished it only with the Lithuanian presidency. So nine trialogues, which is quite a substantial amount of political trialogues. These are the meetings where the 3 institutions meet to, as you know, to find a political agreement. What were the main points for the Parliament, or for the Libe Committee and for the members of the European Parliament? First, I have to say that the Parliament changed the initial proposal substantially. This was in the period.
Sem že na meetingu sem že poslala po četu sporočilo. Nekaj je bilo pri tem narobe, ne vem kaj je bilo. Mogoče, ko sem se prijavila kot bi rekla, ne kot atendi, ampak kot panelista, ne vem, no, nisem te stvari ločila, očitno, ne.
I just apologize because a member interrupted. Turn off the microphone.
Mislim, ko bom morala govoriti, ne, moram zagnati, PowerPoint moram zagnati, ja. A boste vi mene vključili, kako imate to?
Just a second. Lahko prosim nehate samo...
Ponavadi tako je, en je chairman, če je veliko ljudi, on potem da besedo tistemu, ki hoče govoriti.
Just a second, colleagues. I think the colleague is not aware that we have her on the screen with the private telephone call. Mrs. Borka, could you turn off your microphone? Because we can follow...
V redu, torej moram čakati, da mi date besedo, je temu tako.
Just a second.
Potem je dogovorjeno. Vse se lahko preko četa pogovarjamo osebno, ne? Dobro, v redu. Okay.
Dear participants, I ask you again that you switch off the microphone, because we just had the colleague who unfortunately was not aware that the microphone is on, and unfortunately we were interrupted with her conversation, but never mind, just switch off your mic. So I will continue. The European Parliament changed the initial legislative proposal significantly. If you take the initiative from the group of member states from 2010 and compare it with the end results, you would think it's a totally different instrument, a totally different proposal. This was at the time when we got to this proposal, when the European Parliament was relatively fresh in the legislative procedure in criminal law. So let's say, in a way, we were quite innocent in the sense that neither the Commission nor the Council nor the member states were used how to deal with the European Parliament, and to a certain extent this spared us from lobbying, because now this changed after 10 years of this experience. This changed, of course, and the Commission and the member states are used that there is another player in the field of justice and home affairs, and in that regard now let's say the atmosphere of the working methods are quite different than they were in this period, 2012-2013, when we had the trialogues. I will point out 3 main elements where the European Parliament significantly altered the proposal. One of these elements refers to the definition of judicial authority. In the file, as you know, we had the problem that already at that time, before the decisions of the Court of Justice of the European Union, much later on in Kovalkovac and the current cases about independence of a prosecutor and so on, at that time there was no such case law existing. However, we became aware, as well as the Council, about the problem that we called the problem of the Finnish policeman, because in Finland the police has basically the prerogatives of a judicial authority. For example, they can also authorize a house search, or have very, let's say, invasive powers in the eyes of other member states. And because of the problem of this Finnish policeman, we had to introduce a kind of validation procedure. So the issuing authority must be basically a prosecutor or a court. But however, if the initial national authority is not such an authority, it has to be validated by one of these two authorities. However, the European Parliament went even further. And we were also aware about the problem of the public prosecutor. You can have cases where the issuing authority is a public prosecutor, like in Italy, where the public prosecutor can also authorize house searches. However, in other member states, like let's say Slovenia, Germany, and many others, for a house search, if there are no urgent circumstances or no exceptions, you need a court order. So the parliament really insisted that you will find in the definition of the executing authority in Article 2, in addition, that if national law so requires, the executing authority in the member state, in the executing member state, can be or should be a court authority in accordance with national law. So we wanted to address through this, let's say, asymmetric situation where a prosecutor from one member state has prerogatives for certain measures, but this is not the case in the executing state. In that state, such an order has to be authorized by a court. And of course, we wanted to send the message, let's say, if a house search is required through a European investigation order and no court was involved in the issuing state, then in the executing state, in accordance with their national system, a court authorization is necessary. Then of course such a court authorization should be gathered beforehand. This was the first issue that was very important for the European Parliament already at that time, much before the ECJ case law, as regards the different notions of judicial authority. I have to say that in that regard, our members were quite avant-garde, quite already anticipating what could happen in the future. The second problem, or the second issue I would like to mention, refers what I mentioned already yesterday during our conference, the issue of fundamental rights. The European Parliament wanted to have an explicit ground based on a fundamental rights violation, of the possibility of a fundamental rights violation as a non-rejection ground. And you can now find this ground in Article 11, paragraph 1, I think it's point F. However, the way to this non-recognition ground was quite extensive and difficult. Why extensive and difficult? Because first, it was quite rejected by a lot of member states. The situation was a little bit bizarre because the member states in their position accepted a kind of very particular fundamental right violation referring to the freedom of the press. Internally, we sometimes joke and we call this exemption the Swedish non-recognition ground, because in all council proposals, Sweden always demands this particular ground, as freedom of the press is very much cherished or very high in the hierarchy of fundamental rights in Sweden. So it's a kind of Swedish non-recognition ground. So the council on their side agreed to such a ground, very particular fundamental rights ground, but they didn't want to have a general non-recognition ground. The parliament insisted very much about this ground. Then finally, the council, more or less the majority, accepted such a ground. However, then the problem was in the details, how to draft such a ground in the way that it's not too broad, but at the same time protective enough. I have to say that at a certain moment, the council came with a text that would use the ECHR criterion of flagrant denial of justice. You are perhaps familiar with this criterion. It's something from ECHR case law in connection with Article 6, meaning that you cannot extradite to another state someone who wouldn't get the basis of a fair procedure in that other state, be it a Council of Europe state, be it a third state outside the Council of Europe territory. So this is the concept of flagrant denial of justice, but this concept is very limited. And the notion in the parliament was that for a fundamental rights non-recognition ground, this is too limited. For us, the acceptable notion was a reference to Article 6. Then for the council, this was not enough. They wanted in addition a reference to the charter. We were fine with this, as Article 6, as I mentioned already yesterday, mentions 3 levels of fundamental rights protection. ECHR as the minimum, the charter that has to be at the minimum of the ECHR or above it. For example, in the presumption of innocence, we went above it, as the right to remain silent is now an absolute, not an absolute fundamental right in the territory of the European Union. However, by the case law of the ECHR, it's only a relative right, to give you an example. So we wanted a reference to Article 6 because the third level for us that was most important is not the ECHR, it's not the charter. In addition, it's also common constitutional traditions of member states. Why the parliament insisted so much on this Article 6? Because somehow our members were of the opinion that this is a certain dispersion way to disperse the tension in connection with supremacy and primacy and any tensions that might occur between the law of the European Union and national constitutional standards as regards fundamental rights. Basically, now through this non-recognition ground, the EU legislator gave national judicial authorities the possibility to take in certain circumstances also very basic national constitutional standards as a kind of basis to use as a fundamental rights non-recognition ground. Now, I have to say that here the member states agreed to this fundamental rights non-recognition ground. However, in the last years, the development in member states, in some member states, is quite different. And now we have a group of member states that strongly opposes the use of Article 6 in a fundamental rights non-recognition ground. They want only a reference to the charter, meaning that this could amount that your national constitutional standards on fundamental rights are higher than, let's say, the harmonization of procedural rights in the EU, and you shouldn't take this into account. This group of member states, for example, blocked the same non-recognition fundamental rights as it was drafted in the EIO in the 2018 regulation on mutual recognition on freezing and confiscation of orders, which of course is not good for practitioners, that in different mutual recognition instruments we have different fundamental rights ground clauses, because a practitioner does not operate like this, that let's say on mutual recognition of investigative measures and evidence you would use one fundamental rights clause, and then in mutual recognition on freezing and confiscation you would use a different fundamental rights clause. So either you use the same fundamental rights test or you don't use it. But unfortunately, sometimes in these instruments there is also realpolitik. It's not only legal concerns, and you out of real politic issues in this regulation 1805/2018, a different non-recognition ground as regards fundamental rights was adopted in comparison with the European investigation order. So the second important point was the fundamental rights non-recognition ground for the European Parliament. And the last notion I would like to mention before I give the word to my colleagues, a very important issue that we debated till the last trialogue was the issue of non-coercive measures. It relates to Article 10 of the European Investigation Order. You are aware, perhaps, that in Article 10 of the European Investigation Order, you have a list of measures that have to be always available. So a member state cannot claim it's not familiar with a measure if a measure is in this list. And one of the categories is non-coercive measures in accordance with national law. However, the problem was with the English terminology, non-coercive and coercive, because basically in English this could mean, or strictly it could mean, only a measure that is connected with physical restraint. But we didn't mean this. We meant also measures that are invasive or non-invasive. Why this was so important for the European Parliament? We wanted to avoid a situation for member states where, for example, one member state has particular investigative measures intruding into the right to privacy. For example, the use of Trojan horses, so a way to infect your computer by law enforcement authorities and to gather data from your computer. This exists in some member states, but it's not possible in other member states. And if this would be understood as such a measure would have to be available, then basically an executing member state getting a request from an issuing state where such investigative techniques exists would have to introduce or use such a technique that is not provided in its law. This, of course, is not possible under the ECHR requirements under Article 8 ECHR. So the Parliament was very much insisting that we at least mention, because what the problem really arose in the last two trialogues. We mentioned in the last trialogues not to get a definition in the text, but at least we got a recital 16. There you can see a definition what is considered a non-coercive measure. So it's basically measures that do not invade privacy, right to property, and so on. And this was exactly connected with the problem of availability of certain measures, that we would not force member states to use investigative techniques that are not familiar with based on the request of another member state. So more or less, these were the three main points for the European Parliament during negotiations. This issue on coercive, non-invasive measures had also an aftermath when we had to draft the different language versions. We had to be very careful that this is taken into account in other languages, because of course negotiations are in English, but you have to translate the legal text in other languages that have equal value, equal meaning, and this notion was also taken into account when the different language versions were drafted. So just to tell you that here on the European Investigation Order, the European Parliament really played a significant role. If you compare the initial text with the final result, the procedure was also particular, and this is my last word, in the sense that the European Commission did not take part at all in trialogues as regards a debate. They were physically present, but they had basically a prohibition to contribute or to raise the floor in the debates, because this is my personal assessment. The Commission perhaps was a little bit critical at the beginning of this initiative of a group of member states, and this was reflected in the trialogues that the Commission took an extremely passive role, in the sense they didn't take the floor in the trialogue. So it's really an instrument that was drafted only or to a significant part by the Parliament and the Council of the European Union. Thank you from my side, and now I give immediately the floor to my colleague, Mr. Canestrini, a lawyer from Italy. So Mr. Canestrini, the floor is yours.